Chairman, I'm sorry that I'm a
Good
couple
morning.
of minutes late. As the court may be aware, in order to get from where we are until up here requires an escort and a fair bit of logistical support.
It's fine. Is Mr. O'Mara on his way?
I'm sorry?
Is Mr. O'Mara on his way?
I don't believe so. I think he's somewhere else working on his closing argument.
So is he not going to be attending the charge conference?
That's my understanding.
Okay, then you're ready to proceed? If you
Yes.
need a minute, that's fine.
Thank you. I have some instructions put within a larger packet that may be of some assistance as we go through these. There aren't a lot of special instructions that we are proposing, but for example, in the larger set of instructions, I, just as a word processing issue, put proper names in the locations of where the individuals were referenced by defendant, for example. And as this is a work in progress, of course, I can't make all the decisions unilaterally. This has been a work in progress that requires me to have consulted, which I have, with Mark O'Mara, of course, and Mr. Zimmerman, who has not yet been fully brought up to speed on what we're proposing. I got some additional instructions from Mr. Manti early this morning, and I responded recently, so we're still sort of catching up. But I know that we have 3 or 4 hours.
Yeah, we
if
have
need it.
time, so I can make a suggestion that I would like Mr. Zimmerman to have a copy of both sets of proposed instructions so he could follow along, and to afford the attorneys another opportunity to try to work some of those differences out that are minor differences, for instance, the names being injected. Mr. Manti, do you have that information on your computer?
I have an electronic version from Mr. West, yes. I also have the electronic version of the state's proposal.
Okay, so if I took a half-hour recess, would that be a sufficient amount of time for you, Mr. West, to review the proposed instructions and give a copy to Mr. Zimmerman, and to also talk to Mr. Manti, and then we can proceed with this conference?
Yes, I think that would be great. I have a hard copy I can give Mr. Manti to work with, and the court as well at the time we're ready to get down to business.
Okay, thank you. I'll take these back if you'll give me your copy so I can compare them and be ready with you.
Yes. I'll give this to the court, of course, with the caveat that it is not a absolute final set of what we're proposing. It includes our instruction as well as one proposed by the state for comparison purposes. And but otherwise, it's substantially, I think, where we're headed.
Right, thank you. I'll take that, and we'll be in recess for 30 minutes. Thank you. Please be seated. We're back on the record. Case number 12, CF 1083A, State of George Zimmerman. Mr. West, have you had an opportunity to discuss with Mr. Zimmerman the proposed instructions that you gave the court this morning?
For the most part, yes. We're working diligently to get through all of them. There is one issue that I want to raise before we're finished that wasn't included in the package that that was provided to the court related to the lesser offense of manslaughter, but we can deal with that, I suppose, when we get to that particular instruction.
Okay. Mr. Zimmerman, you have a copy of the instructions with you, sir?
I'm not sure, I'm sorry, Your Honor.
Okay, can we make sure he has a copy? Have we done any work to merge the two versions together?
Yes, Your Honor.
All right, do you have now a third version for me, or?
I have two versions with markings on both, but I do.
Okay, you've done it on your copy.
Correct. The first issue is, I think,
Well, whose version, you can be seated, Mr. Zimmerman. Whose version are we operating off of? I've been making my notes too, trying to find the differences in them, so.
I actually, how I found easiest to do it out here and most efficient was I just put them both side by side because
Okay.
much of it is virtually identical language. That's how Mr. West and I went through them. I've identified where the differences in his are from mine and mine from his.
Sounds like a good idea to me.
The first issue is actually a little more global issue. Mr. West has requested that everywhere within the instructions that the word defendant appears, that it be replaced with the words George Zimmerman. The state's position was that there are places where that has been done because the standard instructions indicate that in parentheses, defendant, and then you should put his name. There are places where the standard instructions literally say just the defendant, for example, and that is the reason that the state left that as is, just like with every other case in the state of Florida. So that is the first issue. I don't know that the court considers it particularly meaningful to the jury, but that is the first one.
Is there objection by the state?
There is, only because it appears to be a case of some kind of special focus or treatment. So on that basis, because we believe that this case should be no different than any other that is instructed in this court and everywhere else in the state of Florida, that would be it.
Well, I have noted that sometimes when you use the names are all in caps, and then sometimes they're in the smaller letters. I like uniformity is what I'm trying to get out.
Yes, Your Honor. How would you like it to
And
appear?
I don't think that it is objectionable to have George Zimmerman's name wherever it says defendant. But if we're going to do them all in caps, it's going to be all in caps for both names. If we're going to do it, in small letters, then it's going to be that way throughout. So is that acceptable to the defense?
Your Honor, our submission to the court has it exactly that way.
Well, there was a couple times you put them in caps, so I just want it the way.
That was inadvertent. It was.
Well, I'm just saying I noticed it, and so what I would like them to do is that we all make a decision if they're going to be in caps, they're all in caps. And wherever it says defendant, it will have George Zimmerman's name.
Yes, Your Honor. And would the defense prefer that they be not capitalized, not all caps?
The proposal is that the first letter of the first name and the surname be capitalized, as is typically done for
Okay.
both Mr. Zimmerman and Mr. Martin.
We'll
Done.
make that change, and that will be throughout.
Done, Your Honor. As far as agreement goes, we were in agreement as to the page that begins members of the jury. I thank you for your attention. We were in,
Let's just go from the very beginning, the front page.
yes, Your Honor.
On the defense version of the front page, it just has the style of the case. The second page of the defense proposed has what the state has placed on the first page. Is there any objection to that all being on the first page as the state proposed?
That was a word processing issue, Judge. I took the set of instructions that the state sent to us and worked with that. So other than formatting, we started with the same set of instructions.
Okay, so the first page will be as the state has proposed.
Yes, Your Honor.
And then there was no changes to the members of the jury.
Correct.
We'll make the name changes to reflect this in the statement of charge. All right, that brings us to introduction to homicide.
There was agreement in that until we get to, I believe it's the very last paragraph.
Well, I know that the state yesterday had said that they were seeking manslaughter and aggravated assault, And now they're seeking felony third-degree murder and manslaughter as the lessers. Is that correct?
We are, and Mr. West has informed me that the defense will be seeking 0 lessers at all.
Okay.
So that would be the principal difference.
Is that what the defense intends to argue to the jury? Basically, the second-degree murder or not guilty are the only choices?
Yes.
Okay, I need to make sure Mr. Zimmerman is okay with that. Mr. Zimmerman, please stand up. You understand that the indication from counsel is, well, first let me start off that the Supreme Court, in doing their jury instructions, provides for what they consider Category 1 instruction as a lesser included offense and Category 2 instruction. So they advise us that there are certain crimes that can be a lesser included offense of the crime charged. Category 1 is a manslaughter charge. Category 2 includes a third-degree felony murder charge. And the state is seeking that. Are you aware that your attorneys do not want any lesser included charges being brought before the jury?
Yes, Your Honor.
And you've had discussion with your lawyers about that?
Yes, Your Honor.
And you also understand it's been indicated today that the your attorneys are going to argue in their closing argument to the jury that it's manslaughter or not guilty. Those are the only choices.
Second-degree murder.
I'm sorry, second degree, I misspoke. Second degree murder or not guilty, that they wanted those as the only choices?
Yes, Your Honor.
And you are in agreement with that?
Yes, Your Honor.
Has anybody promised you anything to get you to make that decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
And you're doing it freely and voluntarily?
Yes, Your Honor.
Okay, thank you very much. Please be seated. So I'm sorry I interrupted you. The difference in knowing that the state's changed it to third-degree felony murder instead of aggravated assault, where's the next difference?
The next difference is, actually I believe on the next page, it's the very last instruction. I think the defense proposal is in just a moment I will instruct you, and I believe the state's version says I will now instruct you, or perhaps just I now instruct you. Again, that's one of those differences that I don't think really matters here, but how would the court prefer that to read? The state has it as of now, I now instruct you on these circumstances.
Defense have,
No preference.
okay, whatever the instruction says, so we'll go with the state's version that would include guilty of second-degree murder or any lesser crime.
Thank you, Your Honor.
It's my understanding that we've now addressed and resolved the issue that there are no lesser crimes, so it would simply end before Mr. Zimmerman may be found guilty of second-degree murder.
Okay, well, the state has asked for manslaughter and third-degree felony murder, and I'll hear argument about that.
I see.
Do you want to do the argument now? I don't know.
I can do it now, or I can wait till we get to that point in the
Okay,
instructions.
we'll get to the point on the instruction.
The second-degree murder, I believe it was the same, again, with the exception of the name change issue. The possession
Is
of...
that correct, Mr. West? There are no changes being suggested to the charge of, as it's written for second-degree murder?
That's correct.
Okay.
Same as to the possession of a firearm and discharge causing death page.
There was no objections to that or additions being requested?
You know, if I understand the requested instruction, that's because of the mandatory minimum, or actually because of the enhancement as a result of the use of the firearm.
That's my understanding.
Yes.
And I think that's the standard instruction on that issue.
So there's no objections to how that's written? Thank you.
Now we are at the point where there is the issue about lesser included crimes or attempts, Your Honor. And I guess I'll go ahead and whenever the court's ready, submit that argument.
I'm ready.
Thank you, Your Honor. It's a Category 1 lesser included offense. I have tendered to the court several cases, and I've given counsel copies. The one I think that relates directly to, and now I'm just going to focus on the manslaughter charge, is State v. Montgomery. State v. Montgomery is a little more infamous opinion from the Florida Supreme Court from 2010, which originally declared that the then standard instruction for manslaughter was invalid. However, it is on page 5 of that opinion that I think the most operative language begins. Actually begins at the bottom of page 4 under the heading lesser included offenses. Continues on page 5. But it makes very clear that manslaughter is a Category 1 lesser-included offense of first-degree murder. And what that means is delineated on page 5. A necessarily lesser-included offense is, as the name implies, a lesser offense that is always included in the major offense. The trial judge has no discretion in whether to instruct the jury on a necessarily lesser-included offense. Once the judge determines that the offense is a necessarily lesser-included offense, the instruction must be given. Consequently, at Montgomery's trial for, in that case, first-degree murder, but also here as to second-degree murder, the trial court was required to instruct the jury on the lesser-included offense of manslaughter. And continuing in the next column, the lesser-included offense of manslaughter is just one step removed from second-degree murder. So the state's position is it's a Category 1 and mandatory for a reason. The Florida Supreme Court has said so effective very recently, and it continues to be so, and the state believes that not only would it be error not to give it, but the state is requesting it as well. So as to that charge, at least, I believe that the issue is very clear.
Okay. Mr. West, you want to respond?
Well, we already did, to the extent that this is a decision that Mr. Zimmerman has made knowingly and without any coercion or threat, and his position is the state has charged him with second-degree murder. They should be required to prove it if they can. And if they can't prove it, then that is the failing of the prosecution. Had they wanted to charge him with manslaughter instead because they think that's a better chance under their theory of prosecution, whatever it may actually be, since we haven't heard it yet, they could do that. But we object. We want this to go to the jury on second-degree murder only.
Okay, thank you. Based upon State versus Montgomery 35 Law Weekly, Supreme Court 204, also cited at 39 Southern 3rd 252. From 2010, the court will give the instruction on manslaughter as a Category 1.
Thank you, Your Honor. The instruction as to manslaughter, I don't know that there is any quarrel with how that is worded, because the position, I think, of the defense was that it shouldn't be given at all. So we could discuss that at this point if there are any objections to that.
Given the court's ruling, are there any objections to the instruction provided by the state other than the changing of the names to be in conformity?
The reason for my hesitation is I'm still trying to sort out the evolution of the instruction on manslaughter by act. Of course, the court's aware there are several ways that the state could claim manslaughter occurred. One of them is by culpable negligence. There's no suggestion
There's nothing in the
of that.
information that
So
proves
it's
that.
only by act. And what gave me pause that I wanted to do some additional research on is there's a case from the 5th District Court of Appeal, Cherouse, S-H-E-R-O-U-S-E, that held that an essential element of the crime of voluntary manslaughter, which is what manslaughter by act is an intent to kill. So I've been trying to sort through that. I think maybe, since Cherouse, maybe the Supreme Court has addressed the jury instruction, and that maybe that's addressed in Montgomery. So I think maybe now that law has been, the holding in Cherouse by the 5th District has been now, I think, addressed, although not directly. I don't find a reference to that case in any of the subsequent case law, but I do see that Montgomery from 2010, a Florida Supreme Court case, does specifically say that the intent for manslaughter by act is the intent to commit an act that was not justified or excusable, which caused the death of, in this instance, Trayvon Martin. So I want to be sure that we've got that precise language, and if that's what the instruction says, then I suppose that we're past the holding in Cherouse, even though by jeopardizing it's still considered controlling precedent in this district, unless the Supreme Court has said otherwise. So that was my hesitation. I'm still trying to dig through that.
Okay, do you want us to come back to that one? Other than that, does the state's version of the instruction comport with the Supreme Court's required for manslaughter by act?
It seems to, yes.
Okay, so the only issue we have is your determination that the Charouz case is covered by this instruction.
Yes.
Okay, well, we'll come back to that issue.
Thank you, Judge.
The other lesser included requested by the state, and I should point out, I included the next case, Martin versus State, which is the 1977 decision of the Florida Supreme Court, simply as the reason, and I think I disclosed this to counsel this morning, the reason for the abandonment of the request as to aggravated assault. I think the case makes it very clear that where the victim actually dies, the aggravated assault lesser may not be actually given.
I don't think that the evidence or the charging information support an ag assault.
And therefore, I have abandoned that in its entirety, but I will put the case on the record. The next requested lesser is the third-degree felony murder. As indicated in the state's proposal, and I believe in comportment with the standard jury instructions, felony murder third degree, the state has to prove three elements. One, that the victim in this case is dead. Two, it occurred as a consequence of and while the defendant was engaged in the commission of what's called a non-enumerated felony. And then three, that the defendant was actually the person who killed the victim. The non-enumerated felony in this case alleged is child abuse. Obviously, the information alleges that the defendant shot and killed the victim, that the victim was under the age of 18. And child abuse must be, according to the third-degree felony murder instruction, defined. I have defined the elements of child abuse in the felony murder instruction. And I've also included what I believe is required under the child abuse instruction, which is when the child abuse is premised upon physical injury, that there is a required reference to Chapter 39 to define what that physical injury might mean under the Florida statutes. So that definition has been likewise included. The case law upon which I would rely begins, I think, in the stack that's been provided, with Hermanson. That's Hermanson versus State, which is 604 Southern 2nd 775, which is a Supreme Court of Florida case from 1992. And in that case, as set forth on page 2 of the court's decision, the third-degree murder provision of Section 782.04 of the Florida statutes provides that the killing of a human being while engaged in the commission of child abuse constitutes murder in the third degree and is a felony of the second degree. In that case, unfortunately, the state combined the instructions for both child abuse and child neglect, but otherwise, that was the reason, I believe, that the conviction was reversed. But obviously, the reason the case is there is to show that, yes, third-degree murder premised upon an underlying conviction for child abuse is actually a rational or a listed offense in the state of Florida. The next case to do with that situation is the Klines case. That's CLINES, 765 Southern 2nd 947 from the 5th District Court of Appeal in 2000. In that case, the child abuse was committed by waving a gun around and the gun going off and the child being injured. In this case, the court said, and I'm reading from the second column, it's a one-page opinion, the statutory offense of child abuse is no longer limited to actual physical or mental injury inflicted on a child. It now includes any intentional act that could reasonably be expected to result in physical or mental injury to a child. Further down, the court indicates that what they found in that case, and they described it as irrational, hostile, and reckless behavior by an excited or agitated person, unfortunately often results in shootings, which perhaps were not intended. All it would have taken was slight finger pressure to cause the gun to fire had Klein stumbled or lost his balance, or if the mother, instead of grabbing the child, had tried to disarm him. A bullet released and ricocheting about the nursery was a definite possibility in this scenario, in our view. These undisputed facts and inferences arising therefrom were sufficient for the trial judge to have concluded Kleins' intentional acts placed the child in a zone of reasonably expected physical danger. I couple that with the other case in the state's packet of Garrett versus State, which is 978 Southern 2nd 214. That is the 5th District case from 2008, where we talk about the trial judge supplementing the standard jury instruction, which does not provide the definition of physical injury for child abuse. In that case, and if the court looks at Chapter 39, there is something like 60 different possible types that might need to be included depending on the allegations. In that case, the court included the definition to include asphyxiation, suffocation, or drowning. But the court goes on to say that it is the responsibility of the court to correctly and intelligently instruct the jury in the essential and material elements of the crime. So that is the reason for the definition of physical injury being provided. It is taken from Chapter 39, which, as the child abuse instruction requires, is mandatory to define the type of physical injury pursuant to Chapter 39. The next case is Sheridan, Sheridan, which is 799 Southern 2nd 223, 2nd District Court from 2001. Here again, we have third-degree murder premised upon being a lesser included offense. In that case, it was a first-degree murder charge, but it was third-degree murder, and the underlying offense committed by Sheridan was a non-enumerated felony. In that case, at the time, it was aggravated battery. Aggravated battery, of course, is now an enumerated felony. On that basis, the defense counsel in that case argued the third-degree murder instruction should have been given and was proper. The trial judge was inclined to give it, but ultimately did not. And the court goes on to say in head notes 2, 3, and 4 that the trial judge's first inclination was correct. If, in that case, the non-enumerated felony results in death, it can indeed be third-degree murder. Further, if there is evidence supporting the lesser charge of third-degree murder, the defendant is entitled to such an instruction to the jury. And on to the next page, after a citation to another case, we find the failure to give the third-degree murder instruction in the present case to have been reversible error. The next case is Jakubowski. It's Jakubowski, which is the 2nd District Court of Appeal decision from 1986. And again, here we have a third-degree felony murder. In that case, the victim was 6 years old, based on an underlying felony of child abuse. And in that case, the defendant was charged both with second-degree murder and third-degree murder. After deliberation, actually the court apparently entered JOA as to the second-degree murder. And then after deliberation, the jury convicted of third-degree murder based on the underlying felony of child abuse. And then the next is Spagnuolo versus State, a much more recent decision, which is from June 28th of this year from the 5th District Court of Appeal, and that's Spagnolo. And once again, this is a case where the victim in this case was a child. The child was killed in a homicide fashion, and in this case, the verdict form included a finding or a possible finding for murder in the third degree. And in this case, of course, the problem was that the court conflated, and the state apparently proposed and asked for, a conflation of the abuse and neglect language. The state is not requesting that here. We're requesting abuse only. But the court went on to say, and I'm reading from page 3 of the opinion, as used in 827.03 Florida statutes, which is the child abuse, the definition of child abuse is 1, intentional infliction of physical or mental injury upon a child, 2, an intentional act that could reasonably expected to result in physical or mental injury to a child, or active encouragement of another person. Obviously, there's no factual support for that third one, so it has been omitted in this case. Over in the right-hand column, we continue, and under headnotes 3, 4, and 5, the court quotes another case, which I will get to in a moment. But quoting State versus Sigler, S-I-G-L-E-R, they indicate that a conviction for third-degree murder requires an underlying felony and a jury determination of the existence of such felony. That is why the state has proposed, and we think it's required, to define the elements of child abuse and also to indicate that the state's burden is to prove that underlying felony beyond a reasonable doubt, which is exactly the way the instruction reads. The next case is Alfieri, that's A-L-F-I-E-R-I, which is a 4th District Court of Appeal case from 1998. And that stands for, again, simply the proposition under Head Note 3. And here again, we're talking about third-degree felony murder. But in any felony murder prosecution, the state must prove the underlying felony beyond a reasonable doubt. They don't have to necessarily charge it, although I would submit that the information contains the requisite requirements, but we do have to establish it. So that is the reason the instruction language is given. Finally, Faison, F-A-Y-S-O-N versus State, which is 684 Southern 2nd 270. It's a 1996 decision from the 1st District Court of Appeal. And I'm reading from page 2 of that copy, Head Note 2. The facts in that case, they describe the similarity to another case called Gonzalez, G-O-N-Z-A-L-E-Z. Argued that the convictions of the lesser included offense of third-degree felony murder and attempted felony murder were inconsistent. The court went on to say that no, and I'm reading from the 2nd column at the bottom of the last full paragraph, jury's verdict in the instant case of guilty on the lesser offense doesn't mean that the aggravated battery conviction, in that case the top count, had to be reversed. So the reason that I put this in here, Judge, is to show that I anticipate an argument that the defense would argue this is a legally inconsistent possibility, and I put that in there to say that no, there's nothing legally inconsistent about it. And even if there were, the correct way to phrase it might be a logical inconsistency, and that is perfectly permissible and should be charged that way. That's the reason for the Faison case. So the state's position is as follows, that when one commits a non-enumerated felony of child abuse and the child dies, the child being defined as a person under the age of 18, that constitutes and can constitute, as the cases have illustrated, felony murder in the 3rd degree. I have also provided the court with the case of Sigler versus State, that's S-I-G-L-E-R, 881 Southern 2nd 14, which is a 4th District Court of Appeal decision from 2004. And again, in that case, and I'm reading from page 2 in the right-hand column in the middle paragraph under Head Note 2, third-degree felony murder requires an underlying felony, and in that case it was not child abuse, but it was harboring a prisoner. Second-degree murder, in distinction, requires the killing be done with a depraved mind. Second-degree murder does not require an underlying felony. The court goes on to say on page 3, in the 2nd column at the top of the 1st full paragraph, that the defendant in that case, but I would submit the state equally, is entitled to have the question of guilt for third-degree felony murder submitted to and determined by the jury, so long as the facts are appropriate. Thinking that there might be some question as to whether or not the age of the victim is required to be known by the defense or the defendant, I provided the case of Witt, W-I-T-T versus State, which is a 5th District Court of Appeal case from 2001. And they're pretty blunt and clear that because this is a crime against a child, the ignorance of the age of the victim is not a defense. It would be strange indeed to say the state has a compelling interest in protecting underage persons from sexual exploitation, but not in protecting them from the infliction of death or permanent disability or disfigurement. Contrary view can only be characterized as quaintly Victorian. And so, Your Honor, the state believes that the law and the facts demonstrated herein would permit the instruction on third-degree felony murder so long as it is compliant with the requirements that A, the underlying felony be alleged, B, that the jury is instructed on its elements, C, that the jury is told that it needs to be found beyond a reasonable doubt, and 4, that there is also a definition of the type of physical injury being alleged. And in this case, the state has alleged it means death, permanent or temporary disfigurement or impairment of any bodily part, which is the statutory definition under Chapter 39. That is the basis for the state's request in this case. In other words, second-degree murder requires, as indicated in the case law, that depraved mind. Third-degree felony murder does not require that. It simply requires that the victim be under the age of 18 and be subjected to what constitutes child abuse. Now, self-defense, justifiable use of deadly force, obviously would apply to that charge as equally as to any other. There's no dispute about that. But that is the reason for the basis for the state's requested instruction.
Okay, thank you. Mr. West?
The state is seeking third-degree murder based on child abuse? Is the court going to give this any serious contention or consideration? Because if so, we have a lot of talking to do. We can start with Mr. Manti dumped all of this on us sometime around 7:30 this morning. There was an email, oh, by the way, we've changed our lesser included request from aggravated assault to third-degree murder based on child abuse, and put 10 or 15 cases that obviously he has spent hours, if not days, if not in fact maybe more than a year plotting for this moment when he can spring it on us and the court. Somewhere we wondered why the state would put this vague allegation in the information that Trayvon Martin was 17. No other charge of child abuse, no evidence of anything other than this statement that Trayvon Martin was a minor, 17 years old. First of all, I moved to strike it as surplusage because it's not related to any element of the offense for which George Zimmerman is charged, nor related to any conceivable lesser included offense. So I guess what's happened now since the time that the state filed its information in April, that they've been lying in wait, collecting all this loosely connected child abuse case law where 2-year-olds have been shot by someone who was reckless with a gun, or some child exposed to horrible deprivation or abuse resulting in death. Just so at this moment, on the day of closing arguments, we would have to deal with it. Well, I can say it's certainly consistent with the way this case has proceeded since April, but it's certainly just as disingenuous as well. This is outrageous. It's outrageous that the state would seek to do this at this time in this case. Now, if the court wants to recess for several hours so we can research and review these cases, draft a memo of law, we can do that, and we certainly are entitled to the opportunity to respond in a meaningful way. But it's just hard for me to imagine that the court could take this seriously. Certainly the court wasn't provided with the case law either, nor given any hint that this is where this was going to go.
Well, in all due respect to that statement, the court hasn't been provided a lot of things that have been requested to have hearings that the court has had up until late in the evening, until the last minute, or I requested of it. So that in and of itself is not an argument, and I don't want to go there. So let's go on to the argument about this instruction.
I'm not prepared to make an argument. This was just emailed to me, buried in the set of instructions that the state's obviously been working on for months and months and months, just to spring it on everyone at the last minute. Mr. Manti has this fully formed, organized argument based upon all this case law that I guarantee you he didn't come up with between yesterday when they wanted aggravated assault and this morning when they now want third-degree murder based on child abuse. Really? Ms. Corey's sitting right there apparently approving of this.
That's not proper argument.
It's not
in this
fair
case.
to me, it's not fair to Mr. Zimmerman or Mr. O'Mara or the court for this to happen like this right now. I need time to sort this out if the court is going to give any consideration to this remarkable, remarkable suggestion by the state that somehow third-degree murder based upon an 827, Chapter 827 and Chapter 39 violation of the child abuse statutes could somehow, when Trayvon Martin is shot straddling George Zimmerman, pummeling him, that somehow George Zimmerman was engaged in child abuse?
In the Supreme Court's jury instructions that are online and in the rules of criminal procedure books indicates that the offense charge of second-degree murder, a Category 1, is manslaughter. A Category 2 is third-degree felony murder, vehicular homicide. Non-homicide lessers would be an attempt, culpable negligence, aggravated battery, aggravated assault, battery, and assault. These are part of the jury instructions that have been known to this court since I've been on the bench.
All right, did
So
the court ever for a second think we were
I'm
going
not
to be-
finished speaking.
I'm sorry, I
please.
apologize.
Thank you. The possibility of a Category 2 is known to counsel at the beginning of the trial.
Your Honor, in the same way we would expect vehicular homicide be offered?
But the
It's-
evidence doesn't support that, and the state's argument is, at first yesterday, when they provided the court with the possible lessers, and one of them was aggravated assault, I didn't have any information available to me that led me to believe that that would be a charge that would be given, because the facts did not support an aggravated assault lesser included offense.
Yes.
Their argument today is that the facts support a third-degree felony murder with the underlying enumerated felony being child abuse. That is permissible under the statute. If you need I'm not gonna give you hours. You have, I don't know how many lawyers you have working with you on this case. Well, you have 4 in the courtroom, and I know there's a room downstairs full of people who.
Ms. Truitt's a
bringing me
lawyer,
up.
and Mr. O'Mara is a lawyer. That's who we have as lawyers on this case. Everyone else is a volunteer, an intern who has really done remarkable work, but we can't rely on non-lawyers to do the kind of work that's necessary right now. Judge, this was a trick. Doesn't the court realize this was a trick by the state?
My intention right now is to get through the rest of the jury instructions, because if we have any arguments about the others, I would like to get them resolved. We will come back to this one.
Justifiable and excusable homicide, just as we do with second-degree murder with respect to the third-degree murder and the manslaughter, so that has also been included. The next, I guess, area of discussion moves to the justifiable use of deadly force instruction.
Okay, I'm there. I have both in front of me.
At the court's request, I did attempt to incorporate much of the proposed language from the current proposal being considered by the Supreme Court's jury
Just one
instructions.
second, Mr. West, are you caught up to the justifiable use of deadly force?
No, I'm not caught up
Okay, well, let
yet.
me know when you've got it in front of you.
So we're skipping over the proposed lesser included of third-degree murder
Yes.
based on child abuse.
Yes, we are. We're now on to the justifiable use of deadly force instruction.
I object to the instruction that the state proposes, and I have prepared an alternate instruction that I think the court probably has.
Well, there are some differences, and I know that there are additions in the defense. The state was just informing me that they have incorporated some of your suggestions, and that's where we are on that instruction at this time.
Okay?
As it relates to that instruction, Your Honor, the first line really isn't in dispute, with the exception of the name change. That being, at issue in this case is whether George Zimmerman acted in self-defense. The next difference is in the next sentence. It is a defense to, Mr. West has said,
I'd like to argue my own instruction rather than having Mr. Manti.
I see what the differences are.
sure,
It's a difference in what the lesser included offenses are.
correct. And I don't have an objection to the phraseology in the defense's proposed instruction, such that it would read, it is a defense to the crime of second-degree murder and to the lesser included offense, whether we make that offense or offenses of manslaughter or manslaughter and third-degree murder. I guess that's to be determined, but the way it is phrased is not objectionable to the state. Deadly force, that line appears to be the same. The next marked difference is that the state's proposal is to include the two paragraphs suggested for Section 782.02, being the use of deadly force is justifiable, and it used to read only, but the current proposal omits the word only, and so this state proposal also omits the word only from the standard instruction. So it reads, use of deadly force is justifiable if the defendant reasonably believed that the force was necessary. That entire paragraph, as well as the next paragraph, which defines aggravated battery, which is, as I understand it, the enumerated violent felony or the forcible felony that the defense is alleging was being perpetrated upon the defendant.
Is that correct?
I'm not clear what Mr. Manti is referring to now.
If you were to look at the state's suggested instruction, the third paragraph down, so we're talking about the third and fourth paragraph, it requires for the justifiable use of deadly force for the defendant to prevent imminent bodily death or imminent death or great bodily harm to himself while in attempt to commit some type of enumerated defense upon him.
We're not asking for that instruction. We don't think that it's the issue in our case. I've drafted an instruction that I think specifically addresses the legal issue before the jury and properly sets out the standard that the jury should apply.
So let me just make sure I have this correct, that the defense is not wanting an enumerated felony upon him by the victim in order to have justifiable use of force.
That's right.
Okay. If that's what they want, that's what I'm going to do.
Well, if I could be heard on that.
Yes, you may.
The standard instruction, both the current and the proposed, indicate that that is actually a required instruction because it is essentially if you look at the statutory citation 782.02, that is the definition of justifiable use of deadly force in the Florida statutes. The next paragraph simply defines the forcible felony. So in order to be entitled...
Okay, what section are you saying? I've got the 3.6F, justifiable use of deadly force, the one that's being considered by the Florida Supreme Court.
Correct. There is if you look at the italicized, give if applicable 782.02 Florida statutes, the use of deadly force is justifiable. It is that section, and when you...
But it says give if applicable.
Correct, and 782.02 is entitled, and this is the statute under homicide, it is justifiable use of deadly force. That is what section 782.02 is, and my argument is this is a homicide case, and therefore that is mandatory. That is the reason it's referenced in the standard instruction. It's a homicide, and therefore if they're seeking a request on justifiable use of deadly
Okay,
force.
if you look at the italicized part on page 2,
Yes,
it says, define applicable felony that defendant alleges victim attempted to commit.
yes.
And they're saying they're not alleging any.
If they're not alleging that, then my position would be they're not entitled to a justifiable use of deadly force instruction. Because unless the victim was doing that, we don't have this situation. So if they don't want to allege that Trayvon Martin was committing any forcible felony upon the defendant, then my argument would be what they're telling the court is they don't believe this is justifiable use of deadly force. I didn't take it for a second that that's their argument. That's the reason I put this language in here.
Response?
Yes, the state is seeking this instruction as part of a larger scheme, another trick that the state is seeking,
And I don't want to hear
because,
the word trick anymore in
All right.
regards to these arguments, please.
well, we don't want that instruction. We're not claiming aggravated battery specifically, that so as the jury would be instructed on the elements of aggravated battery. The state wants the court to come up with a definition of aggravated battery, and it can't get that until it convinces the court to include that Mr. Zimmerman is claiming that Trayvon Martin was committing an aggravated battery. This instruction that I provided is exactly the law, and it's the instruction that's in the standard that relates to Chapter 776. That's the justifiable use of force chapter, and that's the language that we used in our instruction because that's the issue. In fact, Judge, it's the only issue in the case. It's always been the only issue in the case, and that is that a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. That's the only issue.
And then that section goes on to say, while resisting an attempt to commit, parentheses, applicable felony upon him or in any dwelling in which he was present.
Well, he wasn't in his
So
house.
it's either the applicable felony or in his house. That's the
No.
that's a justifiable use of deadly force.
No, we disagree.
Well, then give me case law that says that that's a wrong interpretation.
Look under the standard instructions. The standard instructions, actually I have both. I have the proposed ones as well that the court directed us to. The court is looking at the wrong part of the instruction, as is Mr. Mantine. Give, if applicable, under 776.012 and 776.031. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. That's one. Or the imminent commission of felony battery, or I'm sorry, the applicable or forcible felony. In this instance, the state claims aggravated battery, or the imminent commission of aggravated battery against himself. It's an alternative. It's not required, and we're not asking for it. We're asking for exactly what happened in this case, and that is that George Zimmerman was resisting reasonably imminent death or great bodily harm, as this proposed instruction reads, and in fact, frankly, as the old one did too.
These proposed instructions are rather lengthy, and they give a lot of alternatives. The very first one says to read in all cases. Then thereafter, it says give A or B as applicable.
Yes.
Also, there's some instructions to give only if there's evidence of what is seeking to be defined.
Is Chapter 776.012, which the court just read, and the court read it correctly, that it requires, one, justified in the use of deadly force doesn't have a duty to retreat if, one,
That's not
reasonably...
776.012.
It is.
I'm looking at the instruction.
But what I'm saying is the instruction refers you to the statute, and I'm reading the statute.
Okay,
The statute says, "A person is justified in using force except deadly force against another when, to the extent the person reasonably believes such conduct is necessary to defend himself or herself. However, a person is justified in the use of deadly force and does not have a duty to retreat if, 1, reasonably believes it's necessary to prevent imminent death or great bodily harm to himself or herself, or to prevent the commission of a forcible felony, or under another set of circumstances."
okay, they're
That's-
all or.
I'm sorry?
They're or. They're
Yes.
alternative.
Yes. And that is the 012 instruction. The justifiable homicide instruction is what I have written here, which is the 782.02, which I have yet to hear why that is not applicable. Justifiable use of force is required to be given. It is certainly applicable. I don't dispute necessarily that Mr. West's 776.012 might also be applicable. In fact, I include it later. But what he's asserting is it's the only thing that's applicable, and that is where he and I part company.
Okay, that's an issue. What about the rest of the instruction?
The rest of the instruction, beginning with the line, "However, the use of deadly force is not justifiable if you find," the defense has inserted the phrase "beyond a
Okay,
reasonable doubt."
you're going too fast for
I'm
me.
sorry. It's the
What
line that begins,
page?
"However,
Okay,
the use of deadly force is not justifiable if you find," the defense has inserted the phrase "beyond a reasonable doubt" at that point.
okay, I see that. What is the
And-
purpose of that?
I assume it is simply to restate what is said at the very last paragraph on the next page. Convinced beyond a reasonable doubt. It is simply a second place to say it, and if they want it there, we'll put it there too. That's
Okay,
fine.
so that's not an argument? What is the next?
There's a larger issue here, though.
Well, they're not arguing with it being in there, so we don't need to go there.
Well, I included this language as a mirror of the change.
They're not objecting.
But I am, in the
Oh,
sense.
you don't want it included in what you put in yours?
No, I'm talking, I put beyond a reasonable doubt in there, and the state agrees. So we're past that.
Okay,
I included this whole section, which is based upon Mr. Zimmerman initially provoking the use of force against him.
I don't think they have an objection to the section.
No, I do, but I
Well, then why'd
included
you put
it
it in your instruction?
for discussion.
Okay,
Because it only becomes relevant if indeed there is substantial evidence to establish that Mr. Zimmerman provoked the use of force against him as defined by law. And I think the state should be required to articulate the facts in this case upon which it would claim and argue that Mr. Zimmerman provoked the use of force against him. And if they can't do that, they shouldn't be able to argue it, and the jury doesn't need to deal with it. So this, in some ways, can be a misleading instruction, not applicable to the facts, unless the state can articulate to the court's satisfaction that there's some construction of these facts that could establish beyond a reasonable doubt by this jury that George Zimmerman provoked the use of force against himself under the prevailing case law that defines what provoked legally means.
okay, that's fine.
Certainly. Obviously, we are talking about both facts and reasonable inferences therefrom. The facts that would support and the inferences therefrom that would support whether or not the defendant provoked this is that, number one, the defendant followed the victim. He admitted that, actually. Number two, obviously the testimony of some of the witnesses, number one, Ms. Bahadur, who hears a pursuit. Number two, Ms. Gentle, who hears the defendant involved in an interaction with a person who he tells to get off, tells Ms. Gentle he is following me, he is doing this, he's coming up again. She hears a scuffle, a struggle, some physical conduct. There are, I believe Ms. Serdyka saw the defendant on top of the victim. And she said before the gunshot, I understand that's a point of contention and a point of dispute, but it is still a fact in front of this jury and they can draw reasonable inferences from it. So when you combine the known facts that this defendant is the one, at least under a certain construction of the facts and inferences therefrom, who initiated the confrontation, that is provocation. It is not just mere words, as I think is going to be the argument, but it is apparent that there is a physical accosting. There is a close to close quarters. The defense's version, obviously, I think we've gotten pretty clear, is that no, the defendant isn't the one who initiated this or provoked it. It is rather the victim who provoked it. I think the facts testified to leave both inferences equally valid. There are facts to support both, and that is the reason that I think the instruction should be given to the jury. They're free to argue that no, what the defendant did does not constitute provocation, or that the victim did all the provocation. But I think the facts, as testified to by the eye and ear witnesses, as well as the defendant's own statements, and let me add to the fact that when you add on top of that the defendant's own statements, some of them have been shown to be materially, A, inconsistent with one another, and B, false, that those are inferences that the jury could make that the defendant provoked this initial encounter.